All right, good afternoon, everybody, and welcome to our first in-person CLE since March of 2020. It's great to have so many people in the room and so many people online. Before we get started, just a reminder, for those of you that are online, please keep your microphones muted so that everyone can hear and we get a clean recording. This session is being recorded, so just keep that in mind. If you have questions and you're on the webinar, please enter them into the chat and we will relay them to the presenters at the end. So with that, let's move on to the program. We have two speakers today for our CLE on the R.A.V. versus City of St. Paul case. First is the Honorable Edward Clary, retired Chief Judge of the Minnesota Court of Appeals. Chief Judge Clary was appointed to the Court of Appeals in 2011. In 2013, he was appointed Chief Judge and remained in that role until he retired in 2020. In his early days of practicing law, he represented the defendant in the R.A.V. versus City of St. Paul case, which is the subject of today's presentation. He later wrote the book, Beyond the Burning Cross, detailing his work on the case. Our other presenter is Marshall Tannick. He is a shareholder for the firm of Meyer News Tannick. For 45 years, Marshall Tannick has represented clients in a wide variety of legal matters, with emphasis on employment law and constitutional law. He is a frequent CLE speaker and a writer on a variety of legal topics. And with that, I will turn it over to our speakers.
Thank you very much. It's a pleasure to be here. As I was saying when we last convened 2 years ago, because I was the last in-person CLE speaker at this event, and I think that was hockey law in Minnesota. Some of you may remember that, but I'm glad to be back, glad to be in person, and glad to be remote as well. I prepared the PowerPoint, and you'll see there's even a couple of typographical mistakes I caught this morning, but it's too late. So any blame or criticism about the PowerPoint should be directed to me, although Judge Clary did make some good modifications and alterations and revisions in my first draft. So he's responsible for the good parts. I'm responsible for some of the lesser parts. The purpose of our get-together today is to talk about the R.A.V. decision that came out almost 30 years ago, June 21st of 1992, in which Judge Clary was, as pointed out, the counsel for the defendant R.A.V. So while the 30-year anniversary is the jumping off point for our discussion today, current events and recent events certainly color our view of hate speech and hate conduct and where we have been, where we are, and where we're going in connection with those issues. And we are going to touch upon some of those concerns, contemporary concerns as well. We welcome and encourage questions and comments. And because there are so many folks attending, at least remotely, we expect there'll be a fair number of questions and comments and observations. So we're going to try to leave a little bit more than the usual time for wrapping up with questions and comments. So feel free to give us whatever comments or questions you have, and we'll try to answer them at the end, but we will try to leave enough time. So our topic today is R.A.V. Revisited, 30 Years of Hate in the First Amendment. How do I move this here? Oh, there we go. But before we plunge back 30 years, I thought I'd take a brief look at a more contemporary manifestation of this issue of hate conduct and hate speech, and that is, as Judge Clary suggested, starting off by talking about something more current than what happened 30 years ago in the Supreme Court, the legacy of January 6th. We're a year and a half almost beyond the January 6th insurrection. This January, to mark that event, Attorney General Merrick Garland gave an address. It's a very powerful address that I think is worth reviewing. It's online and available, concerning the legacy of January 6th, if you want to refer to it that way. And in his comments, Attorney General Garland remarked, quote, "There is no First Amendment right to unlawfully threaten to harm or kill someone." He went on to quote Justice Antonin Scalia that threats of violence are outside the First Amendment. And the Attorney General cited the R.A.V. case in his remarks referencing January 6th, which I think gives a real contemporary feel to the case that we're going to be discussing. We'll start at the beginning, which is with the ordinance itself. The ordinance under which this case arose was known as the Bias Motivated Crime Ordinance, the City of St. Paul. The statute, the ordinance, provided in part, pertinent part, punishing, criminalizing as a misdemeanor anyone who places on public or private property a symbol, object, or graffiti, including but not limited to a burning cross or Nazi swastika, that the person knows or has reason to know. That's the motivation part. The ordinance addresses conduct in which the person knows or has reason to know, just somewhat of a constructive knowledge negligence standard in a sense, that arouses anger, alarm, or resentment on the basis of 5 specific categories: race, color, creed, religion, or gender. That constitutes, should say, commits disorderly conduct and constitutes a misdemeanor. That's the ordinance that sparked the case. The facts of the case are described in great detail in the decision by the Supreme Court itself, and also in Judge Cleary's book, which I commend you to read. It's a really fascinating account, not only of this case, but for lawyers and law groupies and others, it's a really interesting account of what goes into a case from the very beginning through the state court appellate process, and of course the certiorari process, United States Supreme Court oral argument, the decision by the court, and its aftermath. So I urge you to read it. It's not only very interesting as a historical piece, but it has a great deal of contemporary relevance today. The name of the book is what is the name of the book? The name of the book is, make sure I get it right here. The name of the book is Beyond the Burning Cross, and I'm sure the judge will talk a little bit about the book itself and what went into it. The event happened in the wee hours in the early morning on the first day of summer, June 21st, 1990. A group of youth, I think there were 3 of them, assembled a crudely constructed crosses made of broken chair legs. They taped them together and placed them, they burned them as a cross in the front yard of a black family that had just moved into the neighborhood in St. Paul. The family was living across the street from where R.A.V. lived. R.A.V. was not the only culprit. He was one of, I think, 3. But he was the juvenile culprit, and he's the one whose case made it to the Supreme Court. The others were disposed of in other ways. But the R.A.V., a juvenile, was charged with 2 counts of criminal behavior, including violation of the bias-motivated ordinance that we've just seen. That led up to the ensuing litigation. Oops, I'll get to a minute. Can I get back here? Can you help me a little bit here? Sorry for the technical. Go back a little bit. Yeah, that's one. That leads to the litigation, and that leads to Judge Cleary's role here. Judge, you want to tell us about what happened?
Thank you, Marshall. Thanks for the book promotion too. Good afternoon, everyone, live and on web. Thanks for being here, taking the time to listen to us as we talk about R.A.V. I happened to be watching CNN when Merrick Garland gave that January 6th presentation, so it was very powerful to hear him cite the words of Justice Scalia from R.A.V. and quote R.A.V. Now, going back to the summer of 1990, which was when the incident occurred, it was June of 1990, Dayton's Bluff area of St. Paul, if you know St. Paul. Our position after reviewing the law was primarily based on 2 U.S. Supreme Court cases that were new at the time, Texas versus Johnson and the United States versus Eichmann, otherwise known as the flag burning cases. That was what started this whole appeal, I should say motion to dismiss and appeal, which is that unpopular symbolic speech conduct are protected. And the U.S. Supreme Court had just verified that in those opinions. If you weren't here at the time, it's kind of hard to explain how powerful and controversial those opinions were. I remember talking to Senator Wellstone about it. Wellstone did more for veterans probably than almost any senator in state history, and yet he was in danger because he voted against the flag-burning amendment to the Constitution. It was very controversial. So controversial, after Texas versus Johnson, the Senate voted on what they thought of it, 97-3. I don't know that they've ever voted since that time on an opinion, but they wanted the world to know they thought it was a horrible opinion. That's the setting for 1990. Symbolic speech of the worst kind is protected. So that was our basic argument at the time. So as we went forward to Judge Flynn, that's Charles Flynn, that's how we got the case thrown out in district court. Justice Kennedy wrote a very powerful concurring opinion that appealed to the veterans directly. Charles Flynn was a veteran. I will tell you that no one feels stronger about the burning of the American flag than a veteran, and he dismissed it. Now, the Minnesota Supreme Court took what's called accelerated review. You probably haven't heard much about that because they don't do it. They simply don't do it very often. It's virtually unheard of, and that's David Strauss, who I presented with 20th anniversary, 25-year anniversary, made that clear in his remarks. But they took it. And so there we were. I was in private practice. Mike Cromit from the State Public Defender's Office, friend, was working with me. And at that point, compensation ended. There's no funding to go further. So I called the MCLU, Matthew Stark, who's then the head of the MCLU, and I asked him to take it over because the State Public Defender's Office didn't handle juvenile work then. And he refused, which led to a very intense phone conversation. He was busy defending Ferris Alexander, who was kind of king pornographer in the Twin Cities at the time. And I suggested to him that the case involving a law where the First Amendment had been dismissed on free speech concerns was kind of the reason for a civil liberties organization to exist. And anyhow, they left us standing. So we kept going, Mike and I. All our time now is being contributed. In arguing it before the Minnesota Supreme Court, I could have done a better job, and I've said that publicly since, because we were still skating somewhat on the surface of what was going on here. We were arguing unpopular symbolic speech and flag-burning cases. We also knew that the Minnesota Supreme Court had narrowed a case called SLJ, the disorderly conduct statute, generic statute, to fighting words. So we knew that was a concern. And I was trying to convince them, A, that the speech was protected, and B, that it didn't work, that they couldn't narrow this, that they'd be rewriting the law if they tried. And I did not convince them quite clearly. I remember Justice Yetka giving about a 10-minute discourse on the history of cross burning at the time. And I thought, well, this isn't going too well because that has very little to do with why we're here. We're here having to do with the statute itself and the free speech concerns. And that is a continuing issue throughout R.A.V, which is that, for obvious reasons, many people couldn't get past the factual situation to discuss the law that was underneath it, because it was so horrible and so hateful. So the Supreme Court took the case and they issued an opinion in 6 weeks. 6 weeks. Think about the last time you heard of a Minnesota Supreme Court case coming out in 6 weeks. And that included Christmas and New Year's and all the holidays. So let's just say they pushed it out in a hurry, and they pushed it out unanimously. And they issued it on Martin Luther King Jr.'s birthday weekend, which was frankly salt in the wound for Mike and me, because it left everybody convinced this is all about racism, and had totally missing, again, our argument having to do with the ordinance itself. And there we were. So do you want me to get into the U.S. Supreme Court now, or should we? Okay.
Go ahead and talk. There we go. All right. Well, the case does make it to the United States Supreme Court, and Judge Cleary is going to talk a little bit about how it got there and some of the machinations that went into certiorari and the actual oral argument itself. I want to just touch upon the decision, and then we'll have Judge Cleary tell us how that decision was arrived at from his perspective and what his contribution was. The decision came out on June 22nd, 1992, coincidentally 2 years and a day after the incident originally occurred. June 22, 1992. I think in that year it was the last blast of the Supreme Court. In those days they were finishing up in the third week in June. Now they go to the very end of June and sometimes even into July. But it was one of, I think, their last batch of decisions for that year, for that term. It was a fractured decision, although it was a unanimous decision. Many people have the misconception that unanimous decisions are a rarity at the Supreme Court. Generally speaking, about half the decisions by the court in any particular term are unanimous. That varies a little bit from term to term, but having a unanimous decision wasn't that unusual, at least statistically speaking. This was a unanimous decision, but there were several significant concurrences. The majority decision, and the decision for the court, was written by Justice Scalia. There were 3 overlapping concurrences. Justice Scalia stated at the end of his opinion, not at the beginning, but his last sentence in the opinion stated that the cross-burning incident was reprehensible. But nonetheless, as he noted in the earlier portion of his opinion, it was constitutionally impermissible. The statute was constitutionally impermissible. He viewed the statute as being unconstitutional, the St. Paul Ordinance, that is, as being unconstitutional because it was overbroad. It covered more than was reasonably appropriate to prescribe, and it was also under-inclusive. And he gave some examples. He pointed out that by prohibiting one type of speech, the type of speech that causes anger or resentment under the statute does allow other types of speech that may cause other kinds of emotions and may be socially unacceptable as well. But singling out anger and resentment makes it overbroad in certain ways. It also is under-inclusive because it only directs the proscriptions to particular types of speech or conduct that cause anger, resentment on the basis of those 5 categories: race, gender, religion, and ethnicity, and not on other bases. And as he noted in his opinion, the ordinance only prescribes conduct that affects certain types of people, but not other types of people, and certain types of speech and conduct that's directed to race or gender, ethnicity, but not other types of speech or conduct that's directed to other disfavored or antisocial topics. That, he said, constitutes an under-inclusiveness. As he said in his language, abusive invective is permissible unless they are directed to one of these specific topics of prohibited classes. He viewed this as an upshot as content-based discrimination, because the ordinance prohibited specific types of conduct or speech as pertaining to specific subjects. And he felt that that was in both over-inclusive and under-inclusive, overbroad and not broad enough. There were 3 concurring opinions. Justice White, they were overlapping groupings. Justice White, joined by Blackmun, O'Connor, and partially by Justice Stevens, said the case is a simple case. He said the decision doesn't have to go into such depth in talking about overbroad and underbroad. This case should have been decided by simply determining that the speech involved here, the conduct involved here, the burning of a cross with the purpose of intimidating a Black family, is not within the contours of established First Amendment law. Justice Stevens, partially joined by Blackmun and White, said it was unnecessary to tinker at the First Amendment, and they thought the decision would be confusing because of the way it vacillated between overbroad and under-inclusive and verged into discussing of content-based distinctions without making clear what the ultimate gravamen of the ordinance was. Justice Blackmun had an interesting role in the case because, as we know, he's from St. Paul, and he seemed to be very interested in the particulars of the case and particulars of where it happened. And perhaps Judge Cleary can comment a little bit on Justice Blackmun's role at oral argument. But Blackmun was particularly interested because he's a St. Paulite. And but his decision was a simple one. His concurrence was a simple one. He was fearful that the decision will either serve as a precedent for future cases or it won't. He wasn't sure where the case was going to lead future case law, but he said either one is disheartening. He said either is going to be a precedent, and that's not good, or it's not going to be a precedent, and that's not good either. And he would have decided it on different, more simple, straightforward First Amendment doctrines that existed at the time. Judge Cleary, do you want to talk a little bit about what went into before, during, and even after the oral argument?
I'm gonna since we jumped into the opinion, I'm gonna move back now to how we got the Supreme Court interested at all. Again, as I said, the point that I had left speaking here, we were out. Opinion had come out on Martin Luther King Jr. birthday. We had to make a decision. There's no funding of any sort. The odds of getting a Supreme Court to agree to review, most of you probably know, are slim to none. The largest number of opinions or cases they took was in the late 60s, early 70s. By the time this was coming up in 91, they cut that by a third, almost a half. They hear even fewer now. And as David Strauss has pointed out to me a number of times, there's no way this case would get to the U.S. Supreme Court now. They take almost only federal circuit opinions that are in conflict and congressional acts. They have taken a couple of state cases having to do with the abortion restrictions lately, but generally he didn't think that they'd take this. So going back, we had to get the Supreme Court to be interested, and they're not interested in local or state or parochial issues. It has to have national significance. So how do you give this case national significance going back to it's January 1991. I had done a lot of reading and I had recognized that the language reflected speech codes in college campuses. The same kind of subject matter viewpoint discrimination was going on schools across the country. You could argue, and I would argue, this is when the whole term political correctness was coming into being. As far as I can tell, wokeness and cancel culture are all related to the same issue, which is proper speech and what's acceptable. So that was going on in college campuses. We compared it to college campuses. We used the expression political correctness. So we did two statements presented. You have to get a law clerk interested at the U.S. Supreme Court. This is an IFP in form of paupers. They get thousands. So somehow they're going to open that first page and see questions presented and be interested. So we had two. One had to do with whether or not it was subject to the narrowing the Supreme Court had tried. And two, whether you could engage in this type of law that involved specific groups in such a way that it was picking out subjects for illegality. And obviously that caught a clerk's eye. Because if you ever see an IFP, the proper, so they're not bound, they're not fancy like all the law firms sent in. It's just like a stapled paper that's a little longer. So now David Strauss found out through his contacts in the archives that when it was first brought to the Supreme Court conference, 3 justices voted to hear it. It takes 4. Normally that would result in a refusal to hear it. And one of the 3 could write dissents if they wanted to. One justice, unnamed, asked for another week. And when it came up the following conference, that justice joined in, 4th vote was there, and they took the case. The week they took it, US Law Weekly had, I have a copy of it, all the cases that were presented that week. I think there were 98 of them, and they took 2, and R.A.V. was one of them. They turned down all these federal circuit decisions, all these other cases. They reached out to take R.A.V. And the interesting part is I had always thought they did that in relation to what we had described in terms of the speech codes and college campus and the political correctness aspect. That's why I was so surprised when Justice Blackmun acted shocked in his concurrence that political correctness was involved. Well, it had been involved since we sent in the petition. So I don't know why he was surprised at that. In any case, the Supreme Court takes the case. Now we got to write a brief. And this is the early days of the internet, early days of cable TV, pre-social media of any sort. And so what happened was everybody jumped in. The New York Times, Washington Post, all the major channels, everybody came to St. Paul, Minnesota to investigate the case because it had a lot of appeal nationally. We wanted some help for writing the brief, obviously. We'd never done a Supreme Court brief before. I contacted my alma mater, Minnesota, University of Minnesota Law School, and professors there that taught First Amendment law, and they dodged it. This was controversial. People didn't really want to get involved. The William Mitchell professor, 2 of them helped the other side. A friend of mine at the University of Chicago Law School said, why don't you contact Cass Sunstein? A name many of you may know. He was in the shortlist for a Supreme Court spot with Obama. And I did talk with Cass, and he dodged it too. But he suggested Kathleen Sullivan, who later became the dean of Stanford Law School, and she was at Harvard. And Kathleen did, in fact, volunteer. Once she realized there was no money, she asked about the money. And I explained to her we're all doing this pro bono. She agreed to review a copy of the brief. Now, I'm preparing the brief. I led with a quote from A Man for All Seasons, an exchange, I should say, from Man for All Seasons. And I did so knowing it was non-traditional, which Kathleen pointed out to me, and another law professor at Cornell was a friend of mine, a torts law professor. He said, that's non-traditional, but I think it works. And in that quote, for those of you who are familiar with the play and movie, you know about it. But for those of you who don't, it's Thomas More was the Lord Chancellor of Henry VIII, who eventually was executed for refusing to recognize Henry VIII's marriage. But the exchange was between Thomas More and his son-in-law, who's a very ambitious young lawyer. And they're talking about ridding the world of evil and getting rid of the devil. And the son-in-law said he'd cut down every law in the kingdom to get to the devil. And Thomas More's response, and I'm paraphrasing, is essentially, well, if you do that and the laws all being flat, where do you hide when the winds start blowing? And he concludes by saying, I would protect evil to protect myself, paraphrasing again. And we put that in there and we argued it. And we did not go into great detail about subject matter discrimination, viewpoint discrimination. We were again saying it was substantially overbroad and not subject to narrowing primarily. We did have a little in there, but we did not have a lot on there. And that becomes important because now as the case moved towards the Supreme Court, we had 3 amici on our side. They had 12, I believe. And again, it was still very controversial. One of ours was a far right group, Patriots Defense Foundation from the South. A very far right organization. And we made the decision early on not to tell anyone that they couldn't, in our opinion, contribute, because you don't argue a First Amendment case and then try to censor someone else. So all the amici went in on both sides. So we get to argument that day. Now it's December 4th, 1991. We talked about how close it was to the day of the crosses burn. These are the exact same day that I'd argued here, only 1 year later, December 4th, both days. It was portrait day for the Supreme Court, so all their families were there, just by chance. And they had if you've been to the Supreme Court, United States Supreme Court, it's a very impressive setting, of course. And they had all the folding chairs in the hallway, and David Strauss told me he never seen that. And they did that for overflow back then, and apparently must have stopped that afterwards. So there were congressmen and senators, and it was a packed courtroom, and there were people going in and out because that's how the Supreme Court does it. You get there at 5 o'clock, 6 o'clock in the morning, they let you come in, sit for a while, and then they move you out and move another group in. But you could hear a pin drop because of the carpet and because Rehnquist would get very angry if there's any noise. And you weren't allowed to bring any paper in. So it was a very quiet setting. Now the justices are all there, all 9 of them. It's not a concave bench, it's flat across. That becomes important because you're up there close to them and you're getting questions from all 9. And it takes some time right away to find out which one's asking you the question. So you have to move very quickly. Now, during that argument, the issue came up about subject matter viewpoint discrimination. And Marshall touched on that in his remarks about the opinion. And that became the crux of the opinion, which is this. The categorical approach to First Amendment law has been speech is free and protected, unless it's in a certain category. Libel, fighting words, obscenity. There's a few other carved out exceptions. But within those categories, you cannot betray government neutrality. So you can't have libel against Democrats as a crime, but not against Republicans. You can't have certain subjects and fighting words, like an R.A.V., that you prosecute, but you don't prosecute the other side, because in both cases, the government is betraying neutrality. Now, what becomes interesting, particularly in the light of the recent revelation of an opinion before it was issued, David Strauss was able to get copies of correspondence between the justices on R.A.V., that is to say memos, and he put together the fact that up until, now remember, it's argued December 4th, 1991, and it's almost 6 full months before it comes out. And the controversial opinions, as you may have noticed in your careers, come out at the end of June. The opinion had been assigned to Justice White. The first vote was 9-0. This was over immediately. That's clearly from you had the vote card. They voted 9-0, but how to get there. Initially, the majority of them are going to find that it was substantially overbroad, and they're going to take it down on that basis. Late in the drafts, it became clear that Scalia had a different viewpoint, subject matter discrimination opinion, and it attracted enough votes to take it away from White. Now remember, this isn't all conservative, this isn't all left-right. Souter was in with Scalia and Thomas and Rehnquist. White and O'Connor were conservative, were on the other side. So it isn't that easy to call it political. They simply viewed the First Amendment differently. And as you read the opinion when it was issued, you see White's anger. It was his opinion until maybe a month before it came out. I don't remember exact timing. You see Blackmun's confusion, and quite honestly, Justice Blackmun was at the end of his career at this point. You could tell that at oral argument as well. Marshall mentioned a story, then I'll stop here to tell a little story about that. When I was preparing my argument, I was looking for local people that clerked the Supreme Court. So I lunch with Pat Schultz, who's now a federal district judge next door. And Pat told me 2 things. One was that the exchange in Thomas More was a favorite exchange of Scalia's, which didn't make me real happy because they thought he thought I was playing to him. And Pat said, "Don't worry, you won't think you're that sophisticated." So I thank Pat for that. And then he said, go find out where the cross is burned. And I said, well, I know where it's burned. It was burned at Dayton's Bluff on Earl Street. And he goes, no, in relation to Mullins Park and all the different landmarks, he said, Blackmun can't go through an argument involving St. Paul without asking about St. Paul. to show that he's the St. Paul guy. So I get all done arguing. I sit down. First question for Tom Foley, who's trying to make some remarks initially, which I was allowed and he wasn't, was Justice Blackman asking where it was in St. Paul. And he made the mistake of saying, well, you're up in Davis Bluff. Kind of like what I had said to Pat. That wasn't near enough. Good. And so he kept asking questions about it. And poor Tom hadn't even gotten his argument yet. And he's dealing with these. And then finally he told Tom to have his people cut the lawn in Mounds Park because the grass had gotten too long last time he was there. And I thought, well, his people are assistant county attorneys, but I don't know if they want to cut the lawn, Justice Blackman. Okay. So, but in his opinion, he said he was surprised about the political correctness aspects. That was always there. This was an attempt to kill speech codes. I'm sure we were asking for it in the petition for cert. We were asking for it in oral argument. That's where Scalia eventually went. So I don't know why he was as surprised as he was. Justice Stevens, for those of you who follow U.S. Supreme Court, will know that he hates categorical free speech reviews. He doesn't believe in categories. So his anger was more, this is all too amorphous for me. I don't like categorical free speech. It should be a case-by-case basis. And frankly, it just rambles. So I will leave it there and turn it back to Marshall. I will point out this, though, because Marshall dug this out years ago. R.A.V. remains the most cited Minnesota Supreme Court case that went to the United States Supreme Court by far. Is well ahead of Neer versus Minnesota. Yeah, and that continues to this day.
I think I spoke here last year on the 90th anniversary of Neer versus Minnesota. And I think I made the comment that Neer was probably the most cited First Amendment case in the annals of the Supreme Court. I'm glad you cleared that up, Judge. I'll bet Neer's pretty close, though. I want to take a look a little bit at the aftermath of the case from a standpoint of what it meant in terms of the annals of the law, as well as talking about some current issues concerning hate speech and hate conduct. There are a couple of cases that came on the heels of R.A.V., which are significant, worth noting. One of them I didn't mention on the PowerPoint, but I will. And that's the very next year, in 1993, there was Wisconsin versus Mitchell. That's a criminal case. The issue in Wisconsin versus Mitchell in 1993 was the permissibility of enhancing criminal sentences because the underlying conduct was bias motivated, usually race back in those days. Now there's other different, other categories, but the issue in Wisconsin versus Mitchell was whether the sentence for a crime can be enhanced or increased because the actor, the offender, had a bias motive in committing the conduct. And the court upheld that determination. The court in Wisconsin versus Mitchell held that bias can be a factor that enhances or increases the sentence for a crime. A little bit of a converse, in a sense, of the R.A.V. decision. But really, the R.A.V. decision, as I pointed out, as the judge emphasized, turned on content or viewpoint differentiation rather than the underlying bias issue itself. Another case that is interesting in the wake of R.A.V., although it took place more than a decade later, is Virginia versus Black. That's a 2003 Supreme Court case written by Justice O'Connor. Scalia joined in the decision. It upheld a Virginia statute that prohibited cross burning with the, quote, intent to intimidate. So at the core of the Virginia statute was the same prohibition in the St. Paul ordinance, which specified cross burning, among other features. The cross burning was specified in the Virginia statute with intent to intimidate. In the St. Paul ordinance, the mens rea, or the motivation feature of the St. Paul ordinance, was whether the person who committed the act knew or had reason to know it was intimidating. In the Virginia case, there had to be proof of actual specific intent. and the court upheld the Virginia cross burning statute, basically on grounds that cross burning as an act itself has a long and pernicious history of causing violence. So the court looked at the specific type of conduct there, cross burning, and upheld it. Interestingly, in the Virginia versus Black case, Justice Thomas spoke from the bench. He asked some questions, and that was the last time, I believe, that Justice Thomas had made any comments from the bench until the remote hearings because of the pandemic, when they went by telephone and each judge went by seniority. But that was one of the rare occasions in which Justice Thomas made any comment from the bench. Sure.
Those two cases. I just want to comment on both those two cases, and I'll turn it back to Marshall. I was at both arguments, and I moot courted the lawyers in both cases. Now, in Wisconsin versus Mitchell, Marshall mentioned that there was a enhancement provision. R.A.V. was charged with an enhancement provision too, and we didn't contest that. The theory being that there's a predicate crime first, that there's no way the Supreme Court is going to allow motive to be an additional sentence enhancer, if you will. I don't know that it's smart public policy, but I think it's constitutional. So we didn't challenge it. And R.A.V.'s hate speech, Mitchell's hate conduct. Probably the saddest part of Wisconsin versus Mitchell is that the defendant in that case happened to be African American, flip side. And he got a 20-year sentence for something that would have been normally like 5 years. Huge increase in sentence. And the man who argued it, Lynn Ailman, later became a federal judge. I wasn't at all surprised from day one, from the first moment Lynn spoke, Supreme Court was all over him, pointing out the difference between hate speech and hate conduct. Now, as to Virginia versus Black, that decision didn't surprise me either. Rodney Smola, who's a noted First Amendment lawyer, argued it, and it was pretty clear that they had some sympathy for him. Marshall mentioned this, and you almost had to be in that room. Justice Thomas started speaking, which again, he hadn't done for years and didn't do for years later. I mean, it wasn't just speaking, it was the tone of his voice. And he interrupted the Solicitor General, who was on his side. I later talked to the Solicitor General about that. He wasn't jumping on Smola. And the anger and the vehemence of his remarks led every justice there, because I watched them, turn and look at him. They all stopped what they were doing and turned and looked at him. First, that he's talking at all, probably, and second, the emotion that was coming. And I will tell you that the argument turned on a dime right there. Because as soon as he was done, the questions and the tone changed, and anybody in that room saw it. Now, when it was all said and done and Virginia versus Black opinion came out, nothing of it's too surprising. It's almost as though in our terroristic threats law, we had a subdivision that said using a burning cross with intent to intimidate as a terroristic threat. With intent to intimidate, yes, it is. I thought it was in R.A.V., but they didn't use terroristic threats law. They used something else entirely. Now, Thomas dissented, and he wanted the symbol banned completely. Just like Rehnquist and Stevens and the others wanted burning flag in their dissent banned completely. I once asked David Strauss about how he reconciled R.A.V. and the dissent in Black, and he said, I can't. So clearly, from 1991 to 2003, when Black came out, Justice Thomas had much more strong feelings about the burning cross than he let on in R.A.V.
The R.A.V. case, as Judge Clary mentioned, occurred in the context or at a time when these hate and speech codes were proliferating on college campuses. And many thought that the first case to reach the Supreme Court on that issue would come from a college campus rather than the way it did. The R.A.V. case was somewhat of a death knell for the college campus speech and hate code protocols. They, as well as for many government provisions as well. In the private sector, they've continued for sanctions, disciplinary action taken against employees for engaging in hateful conduct or speech. And they've revived themselves and really gained greater strength in recent years because of events that we've seen, especially in light of the George Floyd incident and others like that. So those are back in play again, at least enforced internally in the private sector as an employment disciplinary matter. But while hate speech and hate conduct codes and protocols have waxed and waned, hate certainly hasn't. Some statistics tell us the story in terms of the compilation of hate type crimes or hate type offenses. The statute passed in 1990, which requires the FBI to try to keep track of hate conduct and hate speech offenses. Back in the early days, and really for quite a period of time, the reporting is somewhat irregular. You can't count on it being totally accurate, and the number of agencies has expanded significantly over the time period. So there's many more agencies reporting these incidents now than there was early. But nonetheless, as you can see from the statistical compilation, the figure was pretty stabilized at about 7,000 for many years, really almost 3 decades. 7,000 or so incidents annually were reported, at least according to the FBI statistic gathering. But it spiked up by a not inconsiderable number to 8,000 in 2020, the last year that I've been able to find statistics for. And that's not an insignificant increase of 15% within a 1-year time period. And I suspect that the statistics for more recent statistics would even show a higher level of incidents. Interestingly, almost 2/3 of the reported incidents are race and ethnicity, at least in the 2020 statistics. That compares to a much lower percentage of race and ethnicity complaints earlier. But race and ethnicity still comprises the single largest by far type of hate and speech offenses that are reported. LGBTQ incidents are rising too, and I suspect that the numbers are underreported there and probably lagging behind more recent developments. Some legislation is worth noting too, and one of the pieces of legislation that I think is attributable in a sense to the not just to R.A.V, but the development since R.A.V is the Emmett Till anti-lynching law, which after more than 100 years finally was enacted by Congress and signed by President Biden at the end of March. That's a federal law that doesn't really have a lot to do with lynching as such, although it's called the Emmett Till anti-lynching law. But it's a federal law that essentially amends existing federal law to provide for up to a 30-year sentence for any conspiratorial. It has to be more than one person. It has to be a combination of one or two or more people who engage in a bias-motivated offenses that cause serious injury or death. But the key phrase there is bias-motivated. That's the phrase that was in the R.A.V statute as well. And that's the federal anti-lynching law, which is much broader than lynching itself, which is non-existent these days, but it extends to any kind of bias-motivated behavior that causes serious injury or death, and that's a pretty heavy federal penalty, consistent generally with the rather harshness of federal penalties. That's the Emmett Till law. It went into effect in March. Another variation I think is worth thinking about for a minute is the discussion about critical race theory and some of the opposition that's arisen to it, particularly in Florida, which is kind of the poster child for some of that opposition. Florida recently passed a law, as you know, under the urging of the governor there, that prohibits for young elementary students any instruction that would cause people to be offended or resentful on racial grounds or ethnic grounds. The purpose is to prevent critical race theory or something like that from being taught in schools. But the language that's used in the ordinance, in the statute, refers to prohibiting students from being instructed about matters that may cause them or their parents to feel resentful or angry about racial issues. That's very similar in a converse way to the R.A.V. statute. Undoubtedly, that Florida statute is going to be subject to challenge on First Amendment and perhaps other grounds. And I suspect that it will lead to some more citation of R.A.V. in terms of whether it's permissible to for the government to proscribe behavior or conduct that causes resentment or anger, the words that come from the R.A.V. statute. As long as we're talking about R.A.V., which probably was the signature case of Justice Scalia's long career on the court, thought I'd just note a few other cases from Justice Scalia that are worth noting. He was involved in a number of other highly significant cases, needless to say, in his 25 years on the bench, more than 25 years on the bench, nearly 30 years on the bench. And some of them have some significant currency today. He was the author of the employment decision of Oregon versus Smith case. That's a case that provides that uphold generally applicable or neutral laws that aren't targeted to specific religious practices. And it's been the subject of significant debate about whether that should be reviewed and perhaps re-examined. Justice Gorsuch, among others, has said that that decision should be reviewed and perhaps modified significantly, because in order to give more grounds to religious claimants to challenge statutes. Justice Scalia was a dissenter in Planned Parenthood versus Casey, the case that reaffirmed, one of the cases that reaffirmed Roe versus Wade. We'll see how long that lasts. But in his dissent, in Justice O'Connor and Kennedy and Souter wrote the key concurring decision in Planned Parenthood versus Casey. Scalia dissented and referred to and said that O'Connor's concurrence that put the majority over the top there, quote, cannot be taken seriously. And Scalia had I won't say a habit, but a tendency to write very sharp opinions, and especially in concurrences and dissents. And O'Connor was one of his most frequent targets, and that's an example of it. He also, of course, dissented in the same-sex case, Obergefell versus Hodges, which may or may not be on shaky grounds, depending upon what the Supreme Court does with the Dobbs, Mississippi abortion case. And as many of you recall, in his dissent in the same-sex marriage case, Justice Scalia criticized Justice Kennedy, who wrote the decision, and Scalia famously said, "If I would hide my head in a bag if I were the author of that decision." Pretty sharp language from Justice Scalia. Where are we, I guess, in terms of hate conduct, hate speech? Well, as I indicated, the statistics alone indicate that there's been a significant upsurge in it. Anecdotally, we see it. And of course, we're seeing horrific events playing out in front of our eyes. One can ascribe a lot of different reasons for the rise in hate speech and hate conduct and violent conduct. I'm not here to elaborate on those, other than to say that it's obviously a pressing problem, a significant problem, and a difficult problem for the law to deal with within the confines of the First Amendment. What happened in Buffalo is not a difficult First Amendment problem. As General Garland said, there's no First Amendment right to threaten or kill someone. But nonetheless, the scope and standards for patrolling and overseeing hate speech on the internet and on social media is a real pressing question today. It's growing as a more significant issue all the time. And I think the analysis of R.A.V. plays a role in determining how far government entities can and should regulate and control that kind of speech and conduct. What do you think about that, Judge?
I have to have a quick, before I let go of Scalia here. I had lunch with Justice Scalia in May of 2015, a year before he died, with half a dozen other people. And I mentioned to him that I'd argued in front of the court when he was on it, and he seemed minimally interested. Then I told him he authored the opinion and I had his attention. And I told him what the opinion was, R.A.V versus St. Paul. And he stopped and he looked at me and he said, very important opinion, cited all the time. And he just kind of stared at my name tag and stared at me a few times. And being the articulate jurist that I am, as I say, I said, good job. Now, to the comments Marshall just made, the difference in the 30 years since R.A.V, the primary difference to me is social media is the biggest change in dissemination of hateful speech. And Buffalo is fresh in our minds. Some of that he probably got from the internet. Some of that he got from Fox News and Tucker Carlson. I mean, the question of how you prevent that without ending free expression is not an easy one. I believe we're the only nation that doesn't censor the internet in terms of hateful speech. Very dangerous for Facebook, Meta, Twitter, to have government regulation involved. They're walking the line because conservatives think they're being censored. And they tell these the social media that the left thinks that they're not censoring enough. And so they get criticized from them. And they're walking this razor's edge. And it's not an easy one. And it's certainly going to result in more First Amendment opinions in the years ahead. But we are still the only nation that really recognizes and appreciates, in my opinion, free expression. The day we start regulating it, in ways that are being talked about, we've ended a unique part of America. And yes, we pay a price for it. But to censor or to government get involved in regulation. I'm going to tell a quick question or a quick comment. There was an article in the New York Times about a year and a half ago from an NYU law professor who teaches First Amendment law. And he teaches, he says the same story every day, the first day of class. He'd gone to Moscow on a conference and he sat next to a law professor. And at a break, he told the law professor, I'm sorry that you don't have the free expression that we have as Americans here. And the law professor took issue with that. And he said, oh, we have free expression. We just punish those who lie. For 10 years, his students laughed appropriately to that. Lying in Putin's Russia, that means you don't agree with the state. The last 2 years, the students have nodded, agreeing with it. That's the kind of thing that worries me. You don't want government regulating truth and dishonesty. United States versus Alvarez was the last comment the U.S. Court had on the stolen valor case, where they essentially said dishonesty is protected under the First Amendment. And that is probably in relation to Putin's Russia. Do we have any questions? Are we done?
Well, to that point, we do have a question about looking at EU regulations for the media, whether that would be a guide, but I don't know.
Yeah, comment. Yeah, you can comment too.
Well, I had a question I wanted to ask the judge, kind of a hypothetical, the kind he used to give to the lawyers in front of him. But I'll comment on the EU in a minute. But let me ask you, can I ask a question of you, Judge? Let's say we have a situation where government monitoring is occurring. As they say, they're monitoring the various social media. And someone monitors someone's social media account. And that person has put on their social media account, I hate blacks. Jews are despicable money grubbers. Hispanics are dirty, filthy people. Asian Pacific, people from the Asian Pacific areas ought not be allowed in this country, and words to that effect. What do we do about that, Judge?
Honestly, not much. That's ethnic intolerance at its height. But what social media is touched with is imminent, the Brandenburg, imminent threat of lawlessness and a true threat. Now, is that a true threat or is that intolerance and hate? The minute it becomes into threatening speech aimed at an individual, that's different. We haven't recognized group libel since New York Times versus Sullivan. So disparaging a group is protected speech, whatever group it is.
Thank you. And now my hypothetical was kind of simplistic. But let's say, I'll just take it one more step. Let's say it's a little bit more than just those kind of statements. Let's say it's a manifesto. Do we take action against those folks who are putting out these manifestos and making these declarations? Or do we wait until the threat occurs and perhaps by that point it's too late?
As long as we're talking about Buffalo, he had already threatened and they hadn't taken action. So you can certainly suggest with law enforcement that they have to be on guard for all of this. I'm not entirely sure what you mean by manifesto. If it's a direct threat, yes, they can get involved and should act and monitor people on the fringes who threaten true threats. And that is the line that Meta and Twitter are walking to this day, and the government as well, is when do you act? Now, there are 330 million Americans right now, third of a trillion. We have unfettered gun laws, which is a whole nother topic for another day. How many sociopaths or psychopaths are there in 330 million people with unfettered gun access? You can make a good argument that it's surprising it doesn't happen more. I have very strong feelings about this, and I think that it starts with access, but that's a Second Amendment, and it's between the First and the Fourth, as one law professor said. So that's where it is. But I mean, again, there is that danger, and it's always going to be there.
Okay, thank you. I guess we shouldn't disregard the EU question. The problem is I don't know what the EU regulations are. I suspect they're somewhat along the lines of what Judge Cleary talked about in terms of European countries being much more aggressive and vigilant in patrolling and keeping offensive remarks off the internet. But I don't know what the EU is. Maybe we'll have to delve down into that. Speaking of which, is an important, very important Second Amendment case. That's between the First and the Fourth, isn't it? Very important Second Amendment case, which is going to be coming out very shortly. It's a New York case involving essentially whether New York and whether the New York requirement of a permit for concealed carry or for any license, for any gun license, for any firearm for that matter, is valid or not. And here in Minnesota, our Supreme Court last year in State v. Hatch, not Attorney General Hatch, State v. Hatch upheld the concealed carry requirements in Minnesota for approval by a local sheriff as a reasonable regulation. The New York case, which is going to be decided very soon, before the end of the term, would, if the observers are correct, the court watchers are correct, possibly overturn the New York law on grounds that it violates the Second Amendment and would essentially create a whole new environment for the validity of state gun licensing laws. So watch for that case before the United States Supreme Court. It's coming out soon. It's the New York rifle and pistol case. Might be worthy of a session here next fall. Any other questions or comments from our chat people?
No, and we are at time.
Okay, well, thank you all for coming and joining us by remote. Closing comments, any closing comments, Judge, looking back 30 years at R.A.V. Are we where you thought we might be? Had you thought about it 30 years ago?
I never understood the social media changes that would become. I don't think any of us really understood what was coming. But I will say one quick comment on the United States Supreme Court. A lot of criticism of them almost any given day. Over the last 60 years, with some exceptions, of course, they have been speech protective. That's the Warren Court, Burger Court, Rehnquist Court, Roberts Court. They have been almost uniformly speech protective. And I think, and that's from the left and the right, and I think that's, they understand, those justices, and always have, how critical free expression and freedom is to Americans. It permeates everything, from the way we speak, to our books, to our movies, to our art, to the way we live. And I think they recognize every time they decide a controversial First Amendment case, and they come up regularly, that they can be criticized, but they understand the significance of freedom in this country. So I have great faith in the court then, and I do now too, at least on that topic.
Okay, thank you all. I think we're done, although I'll stay around if anyone wants to ask any questions of me, and perhaps the judge can stay around for a few minutes either. Don't forget the book, Beyond the Burning Cross, written by Judge Edward J. Cleary. Thank you.